Hello, everyone. Welcome back to Immigration Talk Show. I'm your host, Nipasa, and I'm going to be with you for this session that's lined up. And I'm very excited to have none other than our guest for today. But before that, this very important disclaimer to keep in mind throughout this whole session. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends out there, thank you so much for joining us today. And it's going to be a very awesome session. I can promise you that. And the best thing is, you can also be a part of this by participating wherever you are watching us right now. We are live on YouTube, on Facebook, and also on LinkedIn. You can join and comment. And you can also call us on this number, which you can see above. The number is 425 and the access code is 988888. So yes, join us on call and don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Also hit that bell icon so that whenever we have discussions like these, you're notified and you can be a part of this amazing discussion that you don't want to miss out. So keeping that in mind, friends, thank you so much for joining us today. We're going to be joined by our guest, none other than managing attorney at Melvin Law Group, Robert Melvin himself. Hi, Robert. Thank you so much for joining us after a real long time. Good to see you today.
Hi, Pasa. Good to see you. It's great to be with your group today again, and your followers and your audience, and just excited to talk to you.
The alignment and yes, if you can just check our alignment, and we would love to have you. But excited for today's session for sure. And friends, you can check out none other than attorney Robert Melvin from Melvin Law Group, and he's the managing attorney there. So today's discussion is going to be on this topic. Uh, are EB-2 NIW approvals slowing down, and what the 2025 trends reveal about self-sponsored green cards? So, well, Robert, I'm excited. I hope your camera, are you there, Robert?
I'm here.
Okay, I
Maybe
think you
this is
just need
better.
to check your camera rotation. Okay, all right.
Is that better?
I'll rotate it back. No worries.
Ah,
I think
let me try.
control,
Let me try.
yes, there it is.
There we go. Is that
Much better.
better?
Yes, thank you so much.
Great.
But I'm excited, for today's discussion. But the topic is not that exciting, if I can say, because well, the EB2 NIW approvals are slowing down, and we've seen this trend from the past couple of years, and it's getting slower each year. So, what do you have to say about that?
Yeah, I mean, sorry about my camera.
Okay, I think we are facing, I
But
mean, it's the camera rotating, but I think
hello,
we
can you
can
hear
do it
me?
yes, we can. We can.
Can you hear me?
Yes, we can hear you, Robert.
Hello.
Um, I think control, please suggest if we can continue like this in the portrait form.
Hello.
We can hear you, Robert. Can you hear us?
Hello. I'm sorry, I can't hear you.
I think what we can do is, Robert, if you can actually log in back again, it'll be great because
Um,
you're not able to hear us. We can hear you actually.
I'm not sure. I can't hear you. I'm so sorry.
Um, Friends out there, I think all I can say is stay with us. We will try to fix this situation right now, but you can drop your questions. We are going to take them up very, very soon. Robert is going to join us back. We'll just try to figure out what is the problem with his camera. But nonetheless, I'm excited to have each one of you. So keep dropping your questions, and we'll be right back after this short break.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Hello?
Welcome back, friends, on Immigration Talk Show. Robert, I'm happy to have you back. I hope
Sorry.
it's okay. We will continue how it is, and just happy to see you though.
I'm really good at EB-2 NIW cases. I'm not so great with technology, so sorry about that.
Not to worry about it, because we are here for your knowledge on EB-2 and NIW. So I'm sure the audience
Yeah.
also are here for that. Yes.
So
And
you were
congratulations, by
talking
the
about
way,
the
to you
slowdowns?
and your family, Rob. Can you hear me?
I can hear you.
Yes, I was saying congratulations to you and your family, for your daughter making it to the nationals, and I hope you had a wonderful time there.
Oh, thank you so much. Yeah, that was very exciting. I appreciate it. Yeah, so I think you were talking before I got cut off about the slowdowns in the
Yes,
EB-2 NIW approvals. Yeah,
yes, and we
what
have been
we're
seeing that
seeing,
quite often. Yeah.
yeah, I think what we're seeing is because of all the problems and now the new issues that have come up with the H-1B, that a lot of people are trying to look for other ways to come, and especially, I mean, to obtain residency instead of just a non-immigrant status that you can eventually use to go into resident status. um, so I think with all those problems in the H-1B program that we've seen, my opinion is a lot of those people are just jumping straight into the EB-2 NIW category and trying to basically go for the big case just right from the beginning instead of starting with the H-1B. That's the only reason I can rationalize the increase, because it has been a substantial increase in the number of applicants. So yeah, and that slows down the system. I guess that's the implied message I'm not saying out loud, is that that slows down. So when you have an inordinate amount of people applying for the same category of visas, it's going to slow down the system. It's going to slow down the decision making, and then it will also affect the percentage of approvals. So yeah.
I think that is what we are, going through right now. So I have a lot of questions, but I'm so happy that Christopher has joined us. Hi, Christopher. Thank you so much for joining us on YouTube. We will take up your question. Should we take it up first then? I think we should take up Christopher's question first. I've been hearing from people in my network that EB2 and IW approvals are taking longer than they used to. Is that actually true, or are we just noting the delays more now because of increased interest?
Yeah, it's slowly creeping. Their published decision making time for the non-premium processing cases. So yes, that is increasing. And you can see that if you go back and look at the visa bulletins month by month for the past months, and it's not a significant increase. And actually, sometimes we see it decrease by a couple months. But I think in general, the creep is towards a longer decision-making process. And remember, that's not because the adjudicators are taking longer to decide the opinion or to decide the cases. It's because the amount of cases they have to decide are greater. They still only have about 1 hour to decide each one of these submissions. So it's not like they're taking a longer time and analyzing them more. No, it's due to the workload, in my opinion. I don't work inside USCIS, so I can't tell you, but I can tell you what I see and what I know from being a vice consul and working with that group closely.
So how's it going with Melbourne Law Group as well? You were saying you're an expert in EB2 and IW. So if I may ask, how many cases you're dealing with right now?
Well, we avoid the word expert because it has a legal connotation in the State Bar of Texas. We prefer to use one of our main focuses, EB-2 NIW. We are a small boutique type shop, so we don't have a volume of cases, but I would say we have probably 10 in the works right now for us at various different stages, and maybe 20 or 30 people looking at us to hire us for these cases. We're very careful about the type of cases that we take in this category or any category because we don't want the people to waste their money, right? And we like to win. We are fighters by nature, so we really like to win these cases. So it's going very well. We actually have just got several recent approvals for categories that before the last election would not have gotten approved. We've changed our focus a lot to um, we always focus on what the current administration has as their strategic objectives, their strategic goals for their policies. So, for the first time in a long time, we're having people involved in the petroleum industry approved. We're moving way away from anything that is climate change or DEI or anything like that. We're moving away from those cases. We don't phrase them in that manner anymore, which obviously we did under the last president. So you really have to be strategic when you're going to file these. If there's an election coming up, it's impossible to determine the outcome of the upcoming election, but you really have to play these smart because if there's a huge change in policies at the executive level of our government, that could really affect your case and whether your case is just going to get tossed out or whether you're still be in the hunt for a win, you know?
Yes, got it. But thank you so much, Melvin. That was a sweet introduction to Melvin Law Group as well. So, folks out there, especially in Texas, go check them out. And well, I have questions, like I was saying, and thank you for taking up Christopher's question as well earlier.
Sure.
So, my first question to you, it'll be how slow is too slow? Especially when we talk about EB-2 and
hmm
IW petitions, they have been pending since early 2023. So,
hmm
are such long delays the norm, or is USCIS quietly throttling self-sponsored cases?
No, I don't think they're quietly. I mean, I can't speak to what they're doing. I, I don't think they're quietly throttling self-sponsored cases. On the other hand, I know exactly what you're talking about because the regularly filed ones do have a much longer decision rate, and that seems to be growing, right? And so, for that reason, a lot of our clients choose to use premium processing so that they get a decision um, quicker and they're not having to wait this long period of time. Now, what can that do? There's a theory out there amongst immigration attorneys that, well, if you use premium processing, then that's going to just get you an RFE. Well, I have news for everybody. You're going to get an RFE no matter what in these cases. I've only seen one, and we do a lot of these cases that just sailed through without an RFE. And that particular case had a direct impact on the income of USCIS. In fact, like their proposed endeavor was to attract EB-5 investors, which would result in a tremendous amount of increase in filing fee revenue to USCIS, which is a fee funded agency. So they don't depend upon appropriated funds. They depend on all these fees. That's why they continue to change the fees, make them higher, and charge more fees so that they can continue to do operations. So my answer is if you are tired of waiting, file for premium processing. You can do that midstream. You don't have to do that you don't have to make an election from the beginning. Okay. But be careful if you do, because that also is very strategic. If we're coming up against a potential change in policies, or we know that we want to have case decided under a certain administration, we'll do premium processing with that case because we want to get to the decision quick, to the approval quick under the policies before they change. So you must be very strategic in your use of premium processing and the fact that these are taking longer to adjudicate. So I don't know if that answers your question or not, but
It does. But thank you so much. I think you're basically preparing us mentally, that we should be prepared for an RFE anyway, premium processing or not.
always, always.
Yes. So
And
I'd say it's always best to prepare yourself. Yeah.
one strategy to do is that the RFE is coming, right? No matter what, the RFE is coming. Hold back 20-30% of your evidence and anticipation of that RFE that's coming. That way, as soon as you get the RFE, you have some substantive response to provide. If you shoot everything at once in the beginning, then you're going to struggle very hard to respond to the RFE with any new evidence. Okay. So that's kind of some insider baseball or some strategic ways to plan for these cases. And it's just a fact that you have to do because they use the RFE to kick the can down the road and make the decision later, which makes no sense. They're eventually going to have to make the decision. But if you hold back some material to be able to respond to it, then that's a much better situation than using everything at the first and then being caught with nothing else to offer.
Okay, but wouldn't it be misrepresentation in any way? I mean, if you're not giving out your full info.
No, absolutely not. You're going to give your full personal info. You're going to give many examples of all of your, of many of your accomplishments, but there's no requirement that you have to search out every single accomplishment you've ever had in your entire life and provide it. Some people are so qualified that they only need to provide just 20 or 30% of what they've done, and it's very obvious that they should be approved, so they get approved. It's definitely not misrepresentation. I don't see that angle. You're just providing additional evidence that you didn't provide on the first blush. Some people are pressed for time. Some people are pressed for resources, so they don't have the time or the money to provide everything at the first go.
But really nice tip. I think folks out there, you should hold on to that one then. And Rob, that is a real smart way to tackle things quicker, I think. Not give it away in the first day, but once you're hit with an RFE, you have material to provide. Because when you respond to your RFEs, you need new material to support your statement. So thank you for that. And folks, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. We are live right now on YouTube, LinkedIn, and Facebook on Immigration Talk Show. So check us out. And you can join us on call. Nirav, Sid Mohan, lovely to see you. We have Shamim. Please, folks, feel free to join us on call. The number is 425-436-6335. And when they ask for the access code, dial in 988-888. Well, I see a lot of your questions. We will take them up for sure. But for now, Rob, if you can also tell us, why did EB-2 NIW approvals drop maybe from nearly 19,000 to 14,000 in just 2 years? And have the standard become tougher or demand surge dramatically?
Yeah, 2023 was definitely the golden year. I mean, we were seeing a lot of approvals for cases that were, I wouldn't call them weak, but they're just not as strong as the other cases that we've been able to put forward, but we got them approved. I think they're overwhelmed. It's a limited category. There's a limited amount, so they had to do something in order to kind of make sure that the highest of the highest got approved and that they are able to filter out some. But I also think the way they're adjudicating them has definitely changed. It's pretty easy to gauge whether you're going to hit the marks required for the EB-2. No, I mean, if you have an advanced degree or if you have a bachelor's with 5 years of progressive professional experience, you can pretty much guarantee that you're going to qualify for that piece. So the question is, will you be able to overcome the very high standard of the national interest waiver? Now, the first, they say there are three prongs, but there really are four it's called the Danisar test, the controlling case. And under Danisar, the substantial merit in national importance is the first prong. That's really two prongs, two issues you have to discuss. Substantial merit is relatively easy to show. Basically, that the subject matter of what your proposed endeavor is very important. It's very important to the nation and maybe even international issues. Okay. So that's usually very easy to articulate. But the way they are really hammering people now is in the national importance piece. Okay. And how they are doing that, it's one of the two areas they're hammering people. They're saying, okay, well, great. Your proposed endeavor is of substantial merit to the United States. That's fabulous. But your business plan, your proposed endeavor, as you've articulated it, fails to show that it's going to have an impact on a national or international level. So there's your challenge. You really have to lay the breadcrumbs and link what you're proposing to do, what your proposed endeavor is, to those issues that you used for substantial merit. So, I said I was going to do X, and that is so important to the United States. And here's my proposed endeavor. I'm going to reach out to these clients and we're going to do business. That doesn't work anymore. To say, I'm going to reach out to these clients and do this business. And by doing that, we are going to affect X by creating the Y result, Z result, that will have an impact on the country, on the area concerned as a whole, not just as for the proposed endeavor, or on an international basis. Because if you can't link your proposed endeavor to that kind of impact, you're never going to make it on the national importance prong of Danisar. And that's where they're really getting people. That's where they're really hammering down. So you have to have a very, very good business plan. You have to have very good representation that can articulate how your proposed endeavor won't just make your company successful, but it is going to make the country successful and have an impact on a national level. Before, just by your business plan, like, I'm going to create X amount of jobs, that's going to create Y amount of tax revenue for the local, state, and federal government. That's a big and national impact. That argument used to work. That doesn't work anymore. You're going to have to show that you're going to have a much higher effect on the country's interests and your area of expertise in general, nationally or internationally.
Thank you so much, Rob, for taking that up for us. And folks, I hope you're enjoying this session. Please feel free to share this link, this content with your friends and family who could benefit most from this conversation we're having today. And remember that it's an open one for you also to join us. And I can actually see Nirav also. Let's not keep him waiting too long. Let's take up Nirav's
Mm.
question. He's asking a little similar to what we were discussing a little just now. Do you think USCIS has become stricter with how they evaluate national interest cases, or is it more about the sheer number of applications coming in?
Both. They are being stricter, definitely, and it has something to do with the amount of applications coming in. Both are true. I mean, it's not a zero-sum game. Each adjudicator only has 1 hour to decide these cases. Most of the cases that we present, I would say, have anywhere between 500 to 700 pages on the initial submission. Then we get an RFE, okay? The RFE itself, our response to those, you're looking at another probably 300 to 500 pages of material submitted. And I'm talking about substantive material that has to do with the proposed endeavor, with the national impact, with the accomplishments of the applicant. I'm not talking about reprinting statutes. I've seen horrible cases submitted when we reviewed them. They just reprint a whole statute that's like 1,000 pages and slap it on there. That doesn't work. They know what the statute is. You can cite the statute. If you want to print out, just print out a couple pages of that piece. But it has to be substantive material that you're presenting, articles, citations, everything. And then also, here's their new trick. If the RFE doesn't work, it's like a war of attrition, right? They want you to go away. So the way they can do that is issue these RFEs, and maybe you don't respond in time, and then boom, you're lost. Okay, you're done. So that's one case they don't have to decide. Or they make it too difficult or expensive for you to respond. Boom, you lose. You don't respond. Okay. Or they make it so confusing, as we've seen on a lot of RFEs, that you kind of don't know what to respond to. We'll get these things that come back with super grammar errors. We'll get them that it was obvious that it was an RFE for a different case, but they just put it into ours or copied and pasted paragraphs out of it with misspellings and grammar errors and everything else. And at the end of the day, you're just so confused at what you're responding to that you may just give up. So they're counting on that, in my opinion. I'm not slamming USCIS. They have a hard job to do, and they are overwhelmed and undersourced. So I'm not slamming them, but it's just what we're seeing, right? But this third strategy of theirs is if you can overcome the RFE, okay? Or when I say overcome, you don't just automatically lose by your response to the RFE. They're coming out with a notice of intent to dismiss. So the first time this happened to us, we're like, oh, wow, so they're going to dismiss our case. I don't even know why they're telling it. Why don't they just dismiss the case? Well, don't think like that. It's actually kind of another RFE. They're like, look, your RFE response was okay, but we're going to deny your case. Convince us we don't need to deny your case. Well, when that first happened to us, we just mounted another tack. Now that one we had, a lot less material to offer by the end of the day because we had already gone through the Bain case and the RFE, but we managed to come up with maybe another 100, 200, 300 pages of new evidence. It always has to be new evidence to overcome the notice of intent to dismiss. And guess what? We won the case. So I mean, the stack of papers in that it's more than 1,000 pages with everything that we've submitted. And like I said, they're, substantive pages, substantive evidence, not just fluff. Okay, the fluff doesn't make it.
Wow. I mean, hundreds already sounded so much more. And you said more than 1,000. I can only imagine. And they go through every detail, that's for sure. So if I may ask, what is the thickest number of pages, maybe the most number of pages for an EB-2 NIW case?
I would probably say 1,500 to 2,000, maybe is what
Oh,
we've done. But it's very important. It's not just the pages; it's the substance. And
understood.
they have tools, and I can see that they're utilizing some tools to help them with artificial intelligence in adjudicating these and at least organizing the evidence. I don't know
Yes.
exactly what it is they're using, but I can tell, and it makes sense because there's so much information thrown on them that one person in 1 hour does not have time to read 500 pages and digest everything and intelligently analyze everything and decide, wow, this person deserves to be a resident or not. Or, this is of such national importance. We need this person now, you know? Um, so yeah,
Yes. So we have a question for you, and how, if we can, how to make it a process that would be easier for USCIS, and how to make the questions easier for them.
Well, you have to follow what they need. You have to follow Danisar analysis. Uh, the way to make it easier for them is to provide the strongest evidence of especially national importance. And then the second area of Danisar that they're really hitting people on is whether you are well positioned to be successful in your proposed endeavor. And I mean, before we used to just be able to use past accomplishments and everything else to really get where we needed to go on that. Sorry about my camera, it keeps messing up.
All right.
On the well positioned piece. But now we're really hammering down. We want our clients to try to get letters of intent from customers for their proposed endeavor, show financial resources, either personal backing or loans or gifts that they have that are either in the works or could be obtained to show that they are going to be able to get this thing off the ground. They're going to be able to have success. And it's not going to be a case where they come in as a petroleum engineer and then later on they are mopping the floors in an elementary school somewhere after they get their residency, you know?
All right. Well, thank you so much, Rob, for taking that up. And folks, don't forget to subscribe to our channel and follow us, not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. And I'm very excited to have Helen right now with us. Thank you, Helen, for joining us on LinkedIn. Helen is asking if you plan on holding back 20 to 30% of the evidence of the RFE that is likely to come, how are you deciding what evidence to submit and what evidence to hold back? Have you
Hmm.
seen this be successful in getting approvals after RFE? Very nice question, Helen. Thank you for joining.
Yeah, I mean, it's very strategic and it's based upon our experience. We offer the strongest stuff up front, obviously. Anything that we hold back would probably be in the mid to weaker evidence categories, but you have to have something to respond with. Um, and yes, we're seeing success with that strategy. It's something that we've been employing for quite a while now because we saw this trend early on. Another thing that you can think about doing and that some of our clients choose to do is in response to the RFE, get a professional opinion letter. There's a lot of professional opinion letter writer third party providers out there. It can get expensive, you know. I think they run about 1,400 a letter, but you have a very qualified expert in your field writing a letter d- um, tailored to your specific history, tailored to you and your accomplishments. Now, the adjudicators know that obviously this is a hired gun, right? You're hiring somebody that's just shooting for you. It's not an objective analysis, but in my opinion, they do have an impact. Some of the also another tact that we use is the professional business writers when they provided the business plan on the front end and we had our initial submission and we get an RFE, then they'll do what's called an impact study where they just drill down deeper and deeper and deeper and make those links between the proposed endeavor and the national interest in order to overcome that national importance piece of the Danisar test. So yeah, so in addition to holding back, that's the kind of information we would hold back and then ready for the second round of the fight. And then those are some other strategies that we would use in the second round of the fight.
Very interesting. I mean, I heard this for the first time, but I would say it works for you. So I'm sure you would know which ones to hold back, you know. So, friends, I would always say it's very important for you to, have an immigration attorney for consultation. And why not check out attorney Robert Melvin as well? You can check him out on the link which you can see on the screen and go visit www.melvinlawgroup.com. And Robert, it has been awesome. I think we are almost reaching towards the end of the session, but we have so many questions to catch up on. So let's quickly take up Jay Bhatt's question.
Okay.
With priority date retrogression and processing delays after EB categories, what
Hmm.
proactive steps can I take to secure a favorable timeline and avoid being in future backlogs or policy shifts?
Well, I mean, you can never predict the future, right? So, as far as what you can do to prevent from being in future retrogressions, there's nothing you can do. What you can do is plan your life accordingly. So you know that you're a well-qualified EB-2 NIW candidate. If there's a way for you to get into the EB-1A, which we don't have time to discuss today, you're going to cut down considerably, especially like if you're from India, you're going to cut down the retrogression from 12 years to 2 or 3 years. I was just looking at the bulletin before we started. That's one way. And another way is you can just build yourself up, build up your career, build up your citations, build up your publicity, hire a publicist to get your name out there to hopefully be able to bump up into that EB-1A category. Because if you can do that, you can file another petition under EB-1A, have two pending at the same time, and the retrogression is tremendously less for the EB-1A. If you're not from India, most uh, aside from China and some other countries, I mean, most countries are current in the EB-1A. So that's the golden ticket. We call it the Einstein visa, but I mean, not everybody can get there. But if you're on the margins and you can push yourself a little further up in your international, national recognition and just basically your superhero status and can get to that EB-1A, that's tremendous.
Absolutely. Well, thank you so much, Robert, for taking that up for Jay. And we also have P. Venkata Tish. I'm not sure how to pronounce this. But okay, we also have Sid Mohan's question. When on concurrent H1B, does one need to get both primary and secondary employer stamps when going for first time visa stamping in the home country?
Excuse me, this is about H-1B?
Exactly. So I just wanted to say that, friends, please stick with the
Yeah.
topic for discussion today. It'll be really nice because we already have a little short time.
Yeah. Yeah. I'm not really prepared to talk to the H-1Bs.
No worries, we totally understand. But thank you so much, Peace Ven. I'll just call you that. Thank you for joining us on YouTube. And we have your question. Why is the H4 EAD case status not updating in USCIS website? Thanks. Anything to say, Robert, on that?
Why is the which status? I'm sorry.
H4 EAD case status, it's not updating in the USCIS website, he's saying.
There's they're struggling, folks. I mean, I go to interviews with clients with these officers, and they have a tremendous. They're working like crazy, as fast as they can, and the government systems lag in comparison to technology, as do the private systems. I mean, their use of AI and computers to generate and do the updates and automatically update is much less than the private sector. And then there's another factor that people don't understand. With the government systems, they will hire, they will contract certain softwares, applications, whatever you want to call them, for certain systems, but then other totally different ones for other systems. So sometimes there's internal communication problems, especially if they just procured a new application or operation system for one segment that needs to speak with the other segments, for instance, with the EAD status. Uh, and that could be a problem. I'm not saying that's the problem here, but I've seen it when I worked for them for 12 years. I mean, they just don't mesh, and especially when there's changes and new stuff or bugs in the new product, um, it can just be a disaster, quite frankly.
Well, thank you so much for taking that up. And we do have some questions from our Facebook groups as well, and we'd like to address them as well. So, Robert, this first one is from an anonymous participant asking, does the approval of the EB-5 I-526 depend on your priority date or project approval? Also, is the process taking more than a year due to a heavy backlog on
Yeah.
EB-5?
So again, EB-5, I'm not really ready to discuss that today, except to say that the entire program, I know a lot of EB-5 regional centers is kind of in a free fall. It's not the program that it once was, and a lot of people are not going the EB-5 route anymore.
Right.
People that used to be going the EB-5 route are hoping for the $1 million golden ticket visa to come online and use that money that way. So that's really all I'm prepared to talk about with respect to EB-5. It's just a program that's not functioning well, and a lot of people are steering away from it now because of all the problems that it's having.
Definitely. And for years, it's been backlog. And if you talk about India as well, it's been a sad scene. But
Hmm.
for the next, I wanted to talk about is this is EB-1A, if it's fine, referring to our EB-1A application. Our
Uh-huh.
legal advisor, Chen, asked for an employer letter. Since we're currently on L1B and pursuing EB-1A as a self petition, my understanding is that an employer letter isn't required, as EB-1A doesn't need a job offer or sponsorship. Can anyone with EB-1A experience confirm this? Thanks.
Okay, so first of all, I'm not going to give you legal advice on your specific case because you're not my client. But here's what I will tell you is that the a couple of things. The L1 visa allows for dual intent, so that's a lovely aspect of that visa. And yes, you're correct. The EB1, it depends. The EB1A allows for self-petitioning, doesn't require a job offer. But when you get into the EB1B, and I think in the EB1C, it's been a while, requires a sponsor. So you need to be really clear on which ones allow you to, they call it auto petition or self petition, because not every group in the EB1 category allows you to self petition. So, again, I don't know your case. I don't know the facts of your case. You could be an EB1B, which would require a job offer. Um, so it just depends. I would consult your attorney.
Thank you so much, Robert, for taking that up. And friends, don't forget to check out attorney Robert Melvin in case you also need a one-on-one consultation. Especially, I know you have a lot of questions in your mind with the government shutdown, the H-1B fee hikes, and all these, delays in approvals and processing. So it's always best to consult with an immigration attorney to navigate your cases, to navigate your visas, and keep your documents updated. Always be on your toes, be aware of whatever is going on with regard to American immigration. And for that, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. We come up with the latest updates for you, and ring that bell so that whenever we have the updates or discussions like these, you're notified and you can join us. And well, Robert, if you have a couple more minutes with us, we would like to just take two more questions with you.
Sure.
Okay, so this next question is already on the screen. When the US claims to welcome global talent, yet makes self-sponsoring innovators wait 2 years, does that contradict its stated immigration goals?
So this is an opinion question. I would say most definitely, especially as an immigration attorney. But then you revert to the old New York, uh, you know, saying, "What are you going to do about it?" You know, so there's, yeah, obviously it contradicts, but what are you going to do about it? The
Yeah.
voters can vote, and they vote for who they want, but it's not the substance for a lawsuit. We have a lot of contradictions. As a former government employee for the State Department for 12 years, I could spend days and days with you talking about contradictions within our stated policies and our actions, but it's all speculation and conjecture or opinion at some point.
It is what it is, I guess.
It is what it is.
Yes. Last but not the least, Robert, if you can just tell us, would you still pursue an EB-2 NIW in 2025, knowing, approval might not come until 2027, another 2 years, that is? Or is that, dream beginning to fade also?
No, it just depends. It's all strategy at this point. You got to outthink your opponent. And USCIS isn't our enemy, but they're certainly our opponent because they're kind of wanting to deny in a certain respect, and we're wanting them not to deny, right? So if I was a candidate right now, a potential client, and I had like a really strong STEM, let's say in AI, or if I had some traditional energy, petroleum-based energy type area of expertise, or anything. You can go look at the website, the White House website. If I aligned with any of those things, I would go for it right now, and I would use premium processing to get my approval. Because once you have your approval, who cares if the administration changes? It can go way totally the other way. And then all you have to do at that point, if you're in the States, is wait to get current and adjust status. Or if you're out of the States, go to post and do your interview. But so yeah, so I think it's definitely worth it because once you have the approved petition, then you're just waiting to get current so you can make your move and get the visa. It's not going to be a readjudication of your merits. It's not going to be a reevaluation of whether you align with the national interests. In fact, we had one that got approved in 2023, and she just went in for her interview a few months ago, and total change, obviously, a couple of times in administrations, and she's got her visa. She's moving to the States this month. So, in my opinion, get the lock on the approval and then wait and plan your life on how you're going to make that wait. Whether you're in, if you could stay in status somehow, or whether you're out, what else you could be involved in that could help you, survive until you become current.
Thank you. Thank you for that as well, Robert. Thank you for taking up each
Mhm.
of our questions so patiently and giving us nice ideas. And maybe to wrap this whole session up, if you have any other tips to share with us, especially for folks out there who are dealing with their EB-2 NIWs right now.
Yeah, I mean, it's so the game has changed and is changing, right? But you people that are in this category, you candidates are such a high level, you're high level thinkers. So think strategically. If your area of expertise isn't something that necessarily aligns with the current administration, then maybe you hold off or you think of ways to reframe your position, your area of expertise in a manner that does align. We've done that as well. So you are in the superhero visa category in the EB2 and IW. It's very incumbent upon you to be creative, to make strong arguments, and to come up with strong evidence. So I wouldn't be discouraged, but yeah, it's going to be a harder hill to climb. You just got to want it. And if you don't want it, don't go for it because these cases are hard and they require you to work really hard with your attorney. Your attorney's not going to do everything for you. It's going to be a collaborative effort, a teamwork effort, and they're going to need you to get the information they need to position your argument in the best light possible.
Very well said, Robert. Thank you so much for that. And friends, I'll always say work with an immigration attorney. Whenever you need answers, they'll be the best ones to guide you, direct you on the right path. And with that, I would say thank you so much, Attorney Robert Melvin, today for joining us here on Immigration Talk Show. It was lovely having you, and you have all our answers, for our questions. So thank you.
It's my pleasure. Thank you for having me.
Have a wonderful day, and I hope to see you soon. There's so much to discuss about today. We couldn't finish so many questions, but maybe we can discuss on another new topic, and it'll be great to have you back. Hope to see you soon.
Thank you. Thank you. You too. Take care.
Friends, thank you so much for joining us today here on Immigration Talk Show. Don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram as well. Stay connected with us and maybe reach out to us if you have more questions. Keep commenting. It was lovely having you, interact with us, especially on YouTube and on LinkedIn. Helen, good to see you today. Thank you. And also, you can write to me or call me on my number. My number is 408-335-6444. This is also my WhatsApp number where you can send in your questions or any queries you need to ask. And another thing is you can mail me. That is my email address is nipa@staffingly.com. That said, stay tuned on Immigration Talk Show because there's a lot more coming. But until then, take care, stay safe, and bye-bye for now.